Ladies and gentlemen, I want to extend a warm welcome to everyone joining us today in this webinar. Allow me to introduce myself. I'm Felipe Rota, partner at Pogust Goodhead and founding partner of Rota Advocacia. As the world faces growing demand for critical minerals and mining, for meat and agriculture, for forest and wood, we need to explore how we protect the rights of people living in those lands. The indigenous people who have lived there for centuries, the true guardians of the forests. Today, we're exploring how the law can be used to protect and fight for the indigenous rights, and how organizations like ClientEarth and Pogust Goodhead are using the law to protect the indigenous rights and our environment. And this conversation is close to my heart due to my ongoing work with the indigenous people affected by the Mariana Dam disaster. I stand alongside our panelists to talk about the role of indigenous land in protecting the environment and forests. The discussion will feature ongoing cases from Pogust Goodhead and ClientEarth in Brazil, Australia, and Gabon. I will now introduce our panelists. Carolina Navais Lade, Legal Director at Pogust Goodhead, brings extensive expertise in civil and commercial disputes with a specific focus on representing victims of environmental disasters and advocating for affected indigenous communities. Patricia Jacob, Law and Policy Advisor at ClientEarth, dedicated to important defendants to communities in Gabon for sustainable forest and management, highlighting the critical importance of preserving Gabon crucial forests. And for last but not least, Professor Jeremy Gilbert, Professor in Human Rights Law at Roehampton Law School, internationally recognized expert in human rights law, environmental protection, and indigenous land rights. Thank you all for being part of this conversation, and we hope our discussion today inspires and informs you all. So let's start with Carol Narvaez, starting with our ongoing case against BHP. So if you could start providing like an overview of the ongoing case against BHP and how Brazilian law is being applied by Pogust Goodhead in the UK courts.
Sure. Thank you so much, Felipe. It's a pleasure to be here discussing such an important topic. Thank you so much. So to discuss the case, I think it's important to give everyone an overview of what the Mariana case, the biggest collective claim existing as we know of, happened, what are the facts and players involved in such a gigantic case. In 2015, the Fundão Dam in Mariana, a city in Minas Gerais, collapsed, causing not only pollution of a river and its adjacent rivers, but also the death of 19 people. The villages were completely destroyed, river completely contaminated, and with this, public authorities filed claims in Brazil. So we have what is called public civil actions in Brazil that were filed by the authorities soon after the collapse in 2015. Those claims were mainly focused on filing or on getting the companies to compensate the victims of the case. So they were filed against Samarco, which is a joint venture run by BHP and Vale. 8 years have passed, and sadly, the conflicts have not been resolved, and several compensation models were discussed and proposed over and over again. Up until today, there are hearings that happen with indigenous affected communities to discuss and rediscuss the compensation models. No agreement was reached up until this moment. Seeing the situation in Brazil, PG started the collective claim here in the UK. This claim was brought against the Anglo-Australian company BHP, so the controllers of BHP Brazil. We have 700,000 plaintiffs. Among those plaintiffs, we have individuals, we have businesses, we have municipalities, utility companies, and indigenous and quilombolas, which are classified as the traditional communities we have in the claim. Just to give everyone a little explanation about who the quilombolas are. The quilombolas are African slave descendants that suffered a lot of persecutions in Brazil, not only because they were descendants of slaves, but also because they suffered a lot of prejudice due to their condition. We also have the Indigenous, which is a traditional community protected by our federal constitution, Brazilian federal constitution. And this is the topic of discussion today. The reason why the claim is existing here in the UK is because the court, while judging the jurisdiction application, decided that the complex legal proceedings in Brazil, as I mentioned, up into today, 8 years after the collapse, nothing has really happened in Brazil in terms of compensation. The lengthy duration, this is something that we see in all those type of claims that are started by public authorities. They go on and on and on. Nothing is ever conclusive. A lot of applications are filed. A lot of petitions to suspend the cases, to discuss the smallest things, and the cases never really end. A lot of uncertainty regarding the claimants' possibility to start those claims again, the Anglo-Australian companies in Brazil, and the unattractiveness in general to starting the claim in the Brazilian courts, because there are, like I said, many studies that show that this type of claim, this type of collective claim in Brazil, led by the public authorities, take a long time and are never fully resolved. Therefore, the court decided that the case would be run in England until the judgment of merits. Now, a two-stage trial is planned for these proceedings. The stage one will focus on the defendant's liability, so BHP liability, under the causes of actions that we presented on our particulars of claim. And the stage two will focus on quantifying the claim. The long-lasting effects of the disaster are felt until today by the indigenous communities. Many damages include socio-economic interactions, such as the difficulty to sell the fish because no one will trust the fish that comes from the river that was polluted, because everyone thinks and believes that the fish is contaminated. We often receive from our clients footage of fish with cancer and very strange tumors. So this is something that is still very present in the communities. And in addition to that, the fact that the communities are not able to have tourists the way that they did before. They sell less of the handicrafts that they used to produce because they don't have as many people visiting their communities, etc. These are just a little bit of what they still feel in general. There are so many more damages, such as the environmental damage to their land in general, because the river was contaminated, their land is contaminated. The damage to their practice, traditions, and cultural heritage. So the river Doce was, for some of the communities, such as the Krenak communities, divinity, and they can no longer carry many of their culture and religious practices now, because they are linked to the river and the river is polluted. So their baptisms, their passage rituals, their marriages that used to be performed in the river, they are now not being held, and therefore they suffered a damage to their culture and tradition. Another example is for the Tupinguarani, which is another affected community by the collapse of the Mariana Dam. They're also a traditional community, and all their culture was also based on activities on the river. So on a Friday night, they would go to the river. They would have this specific this specific activity. Everyone was drinking and dancing and singing with the children. Now they don't do this anymore. That was over after the collapse. In addition to what we called non-cultural damages, so psychological harm. That's the rivers where they had their leisure, daily activities. That's where they learn to swim. That's where they go for have a time off, and they don't have this anymore. One interesting thing that Felipe sent earlier today is that yesterday, some of these affected communities had to go to a club, to a swimming club, to play in the water, because they don't have this anymore, right? They have to be creative about the way that they will have their leisure, because the river simply is completely polluted and unsafe for them to be there. Consequently, this will cause sadness. If you have your entire cultural activity surrounding a specific place that now it's not possible for you to have the leisure there, that will bring profound sadness, psychological distress, the inability to pass traditions, the fact that your son won't learn how to swim the same way that you did, because it was second nature to indigenous people, to an indigenous person that used to live in that specific area, just to learn how to swim. And this is not happening anymore. This is not happening. In addition to this, loss of drinking water supply. The river was a place that they wash their clothes, they drink the water, and that's not there. Damage to property. So many indigenous people used to fish. The equipment now is completely rotten. They used to have little boats to do their activities. Because these tools are not being used, they're getting damaged. And that's what we call the most common effects or most common damages that they are sensing. The case is run by English procedural laws and Brazilian material law. So it's a little bit of a mix between both. And I guess that's it in terms of the case, an overview of the case, especially in relation to the indigenous communities, Felipe.
Okay, thank you, Carol. That was a very good overview of the case. But I think like in this case, Pogust Goodhead represent different cohorts of claimants. So like many different classes of claimants, like municipalities, business, individuals, churches. In the specifically in the case of the indigenous, could you give like if there give us like provide us if there's any key lesson or insight from your experience in this case that you believe would be important for the protection of indigenous rights?
Sure. Yep. That's a very good question. And I think that's the main difference that we see in relation to our case and what has happened in Brazil, because what our clients usually compliment us in is the fact that we actually listen to them, we listen to their complaints, we listen to their needs, we listen to what they think is most relevant. Not we don't have the paternalistic view of what a public authority would have in such a case, right? And I think that's the main insight anyone can have working with traditional communities, indigenous communities, is that we should not be taking a paternalistic approach. We should make sure that that they are heard and they participate in the process of decision making. As a parameter to ensure the participation, you can always go to the ILO convention. It is a cornerstone, but there are other agreements such as the Escazú agreement that aims to foster transparency, inclusivity, and accountability in environmental issues. In Brazil, there have been some developments in the law. There is a decree in Minas Gerais that was implemented this year, and I think it all relates to the fact that Minas Gerais specifically is a state that has a lot of mining activities. Indigenous communities suffer really hardly the consequences of the mining activities. We all know about environmental racism. That's something that you can see over and over again in Brazil, and I think in the world. It's not specific to Brazil. The fact that companies will go to the ones that have the less arsenal, the smallest arsenal, to discuss with them and provide and perform their activities in these areas. And this is all very important to take into account. The less information, the less technological knowledge, financial resources, the more the companies will try to establish their activities. And these asymmetries, they will impact on the legal proceedings, on how people actually perceive the damage. And yeah, this is a situation that we see and that we could all learn from different cases that are held. One thing that's interesting to look into is how the companies act. So in this case specifically, in Australia at BHP's AGM in Adelaide 2 weeks ago, I think, they talked for 30 minutes about how they protect the traditional communities, how the traditional communities are important for BHP, but they are completely overlooking the fact that it has been 8 years since the dam collapse, has been 8 years since these communities were severely affected. They are feeling all the impacts of this disaster, and until this day, BHP could not make it right for them. So this is not exclusive to BHP, this is related to the case, but we know that companies will go and act like this. So to summarize, these conversations, they have to stop being theoretical, they have to start being more fact-based. People should be heard, the companies should be held liable, and need to ensure that the affected communities are heard in a process of making things right.
Okay, thank you very much, Caroline. I completely agree with you on this paternalist behavior of the government and also of like the institution of justice that usually has the duty of protecting indigenous and traditional owners. But because of this paternalist behavior, usually the indigenous are not consulted, usually the quite the remedies and address to protect those communities usually are not properly suitable for them because of lack of consultation to these communities.
Yeah.
And usually this happens because of the common sense. The indigenous people are uneducated, ignorant, and they don't understand of their rights, which is completely not true, especially here in Brazil, where we do have a lot of education on indigenous rights and advocacy programs. Of course, there, like in any community, there are people that are not non-educated, but it's not like we can like generalize every single community. And this goes to a very good hook to speak now for our guest, Patricia Jacobs, that works with the education of their legal rights and the forest law to those communities. I would like to ask Patricia to draw like how is this concept dealt, and like how and if in Gabon there is this paternalist behavior of the government of not letting the communities decide by themselves, or like understanding like how the government deal with those communities.
Thank you, Felipe, and thank you everyone for the opportunity to be on this panel and to talk a bit about our work in Gabon and in general in Africa. I like just to start with a quick intro for those who don't know ClientEarth. So we are an environmental charity that was set up in 2008. We work globally across 8 offices. And at the center of our work, our legal system, rule of law and justice, to strengthen environmental rule of law, fundamental rights, and ecosystem governance, and to empower others to use legal tools to tackle climate change and protect ecosystems. And before replying to your question, I just want to insist on the fact that Indigenous peoples and local communities are by far the best guardians of forests, because we work extensively on forests in Africa, on protection of forests, and protecting the right of these communities is at the forefront of forest protection in both national and international law, which is an essential part of tackling this deforestation crisis. in order for us to work with governments and with local communities, we decided we took an approach to working extensively in partnership with local organizations and forest communities to help shape the laws, to build legal capacity and to support advocacy efforts towards the development of consensual forestry laws conducive to improved and community-driven forest governance. Because of what you are saying, Felipe, this paternalist view, governments ignoring rights of indigenous peoples and local communities or refusing to acknowledge them. And given that there are certain international commitments that countries have, we took on this approach on focusing on helping shape these laws so that they are strong and they can protect the rights of indigenous peoples and local communities. And in Africa, for example, we work in high forest cover, low deforestation countries, among which Gabon, but we also work in Congo and Liberia. Or we also work in very deforested countries, which experience among the highest primary forest loss globally, such as Ghana and Ivory Coast in West Africa. And as I was saying, our approach in Africa is one of not leading litigation cases in national courts, because we think it's more effective to focus on, so we have this long-term vision of multi-stakeholder, transparent and fair ecosystem governance. We aim to increase the legal capacity of local actors, NGOs, indigenous peoples and local communities and governments to increase the credibility of their voice in national governance decisions. We aim to increase the accountability of the legal system via public transparency and participation, and to empower and defend indigenous peoples and local forest communities. And we work extensively in partnership and through national lawyers and civil society organizations. And currently, our topics of work are, for example, law reform in Congo, community forestry in Gabon, similar in Liberia, and cocoa production and trade in Ghana and Cote d'Ivoire. And to go back to Gabon, which I like to say it's the second most forested country in the world. It has an 88% of high carbon, high conservation value forests. And it has, for example, one of the most progressive forest codes in the region, which enshrines concepts like community forestry. Community forestry is now one of the most promising approaches to protecting forests and to improve the livelihoods for forest-dwelling communities. However, in practice, these rights are not always upheld by strong enforcement of the law. And for those listening to us and who are not familiar with the concept, I'll just say that community forestry is a way of implementing social forestry, which puts the focus on local communities as a key player in ensuring sustainable forest management. It allows local people to directly manage the forests in which they live and upon which they rely for their livelihood and survival. And under such a system, they basically have a vested interest in improving their living standards while protecting the environment they live in. We've been working for nearly a decade in Gabon, and our aim is to have a strengthened legal regime that promotes community forestry and IPLC rights. And for this, we work, let's say, on two fronts. We work with civil society to ensure that they have an increased participation in legislative and implementation processes linked to community forestry, but also with communities to ensure that they have an improved capacity to manage their community forests in line with the law. And in terms of that means like how we work, we focus on capacity building of community members, capacity building of CSOs, We have in place a women's rights and gender equality program. We offer ad hoc support to targeted communities. We are striving to build networks, and we conduct legal analysis and support civil society in such initiatives. And what I like to say, to add to this, for example, when we work with CSOs, we aim to address a general lack of information and representation of civil society. We do this through legal training and support to civil society platforms. We have put in place a legal working group which gathers on a more or less monthly basis representatives of civil society organizations to discuss topics aligned with the forest reform initiatives, to analyze legal drafts, to propose strong advocacy documents. And just to give you an example of results of this strategy, for example, in 2016, we supported a successful campaign by Gabonese CSOs, which has led to the government to adopt guidelines describing how the sharing of benefits should operate, teaching basically in the benefit of communities. And thus communities were equipped with, in practice, with a rigid framework, allowing them to hold logging companies accountable where they stepped outside of legal provisions. And when it comes to work with local communities, we work in very close collaboration, as I said, with in-country partners. They conduct regular training missions in 2 selected provinces in the country. We offer technical training, and to ensure the sustainability of this work, we have set up a continuous training system through 2 field officers who are based in the provinces. So they offer ad hoc support, they conduct monthly training missions, they animate radio shows to bring awareness of this concept, which in some areas is largely ignored. And we've started to see also changes in local practices already, with communities reaching out more and more for support, with certain community forests that have resumed work after having been suspended for several irregularities. And also we aim to ensure the sustainability of our efforts through tight collaboration with the forest administration as well, at local and national level. And I will stop a bit here because you may have questions. Thank you. Sorry, I think you are on mute.
Oh, perfect. Thank you. Sorry. So I would like to ask, in your experience, what are some of the key legal and policy reforms that are needed to further empower forest-dependent communities and protect their interests? Because, like, for example, here in Brazil, we now have a really important legal battle for ownership of the traditional lands. So I think like this is like quite key and specific for the future of indigenous people here in Brazil. I just wonder like if there's anything happening like this in Gabon and some kind of policy that you guys are working on.
Yeah, thank you. That's a really good question, and it's also an opportunity to highlight the difference between the American and the African realities. Because in Gabon, for example, this is actually one of the main issues when we talk about communities' rights, is securing their land rights. And let's say that the legislation is not as advanced as in South America, but this concept I was talking about, community forestry, is a big step ahead into that direction. And Gabon is a country which has a lot of forest concessions. So in a way, that overstep communities' traditional lands. So we are having a bit of a problem there, but there are certain initiatives now towards proposing a law that would recognize community-driven conservation areas. So that would be a very promising law that would manage, this problem with land that is not so much available anymore, and also recognizing communities' traditional lands and territories. So this is one of the key issues that we're working on right now: land rights, also this community-led conservation, and let's not forget gender, the gender component as well, which is a topic that again is not as developed as in South American practice right now.
Okay, thank you. And a little bit connected to this question, it's a more general question for like the way ClientEarth represent the community. I would just like to understand, like, I think usually it's difficult to select or to identify who has the legal standing to represent those communities, right? Or even like if more than one person has a legal standing, who would be the ideal person to do it? It's just because we were talking about this legal issue. I was just wondering, like, there's anyone that has legal standing to represent the community, or if there's any institution of justice that will have this legal standing, like the public prosecutor office. How ClientEarth navigate in this area, because we have something similar in Pogust Goodhead.
Yeah, thank you. It's a good question, and it highlights why basically we have chosen to orient ourselves more towards non-courtroom advocacy work in the case of Gabon, rather than, say, strategic litigation, for example, because we think it's extremely costly. Trials are unpredictable, and we know that we cannot rely on implementing, even if, say, we would have like a positive outcome in a trial, we cannot rely on implementing laws and on policies, and yeah, that would be so it's just we prefer to go to awareness campaigns, lobbying, community outreach, just because of these problems, like with legal standing, and laws that are not so robust right now. So we prefer to support now building a strengthened legal regime that would help in the future this kind of actions. So
yeah, like I feel like that it's not only difficult to navigate between like domestic laws in those countries, as well as through the leadership in those communities, but especially what I feel which is a really difficult, challenging on working on this specific niche of law, is because we are working on transnational law, which requires law of two different jurisdictions, and then we are also need to think that we're talking about traditional people that has their own traditional custom, their own law, and then we have to translate two times this all those customs, and we cannot, we can be like, and can be a lot of mistranslations in this when we try to do the conversions, especially because it's not only about language but also the perception of the world. So I think now it's a really good timing to move to Jeremy, and he can tell us a little bit about how he has been developing his expertise between the human rights, the rights of nature, the traditional community, and how all these different views of the nature and the world can be connected and related.
Yes, thanks, Felipe, and hello, everybody. Thanks, Caroline and Patricia. I suggest I go straight into that question that you started with, Patricia, which is the relation between litigation and community empowerment, because I think that's really why we're here. Before I do so, I'm going to explain why I'm coming to this angle. So compared to Caroline and Patricia, I'm not working for an NGO. I'm what we call an activist academic, which is using the freedom of academia to work with the communities. I'm speaking not only about one case, but a few cases. So I've been invited to support communities when they try to bring human rights law into their proceeding in front of the court, which is always a bit tricky because we know we have those fantastic declarations at the UN level, the UN Declaration on the Right of Indigenous Peoples, for example, but it's lacking something at the national level, usually, which is the law. It's lacking the judgments. The judges are not aware of it. The lawyers are not aware of it. So my job has been really to support the community and the NGO that work with them, and to name them, usually I work with the Forest People Program and Earthright International. I've been working in cases that concern communities in Colombia, Suriname, Malaysia, Namibia, and at the moment in Uganda and Kenya. I'm not going to talk about all those cases, but I'm going to use learning from those cases to maybe go to the conversation on the role of litigation, but also the limitation of that. But maybe to pick on Patricia's point, I might talk about cases that really concern conservation, because it's something I've learned really over the last 20 years is Indigenous peoples are the victim of conservation in many places, meaning top-down imposed conservation by both government and international organizations, including UN level, that disregard Indigenous relationship with their territory. To give you an example, which is ongoing at the moment, I don't know if you've been following the news, but there's a community, the Ogiek people in Kenya, that are facing expulsion as we speak. Their land has been, again, taken by government, and it's all done in the name of conservation by the government. But in reality, it's to grab the lands and to actively dismantle the community. I invite you, when we finish the talk, to just Google Ogiek people, Kenya. They won an important case in 2017, which is often seen as a landmark case in front of the African Court of Human and People's Rights. But despite this victory in the courts, they are facing, as we speak, violent discrimination by the government that is actually burning their camps at the moment. So I'm going to use that to see what is the value of human rights law, knowing that it's really hard to implement on the ground. But instead of talking about the case of the Ogiek, if you allow me, I'm going to talk about another case I've been involved, which concerns Uganda. The Batwa people live in southwest Uganda. I'm using that case because it has all the ingredients of what we've been talking about. They've been facing expulsion from the land for the last 40, 50 years. Again, in the name of conservation, it's a beautiful part of the forest that is being quite protected because the communities used to live there and maintain it well. The government decided, for reason of tourism, but also conservation, to forcibly expose the communities. Under the law of Uganda, there's very limitation. There's no protection for Indigenous communities, basically. So they turn to the supportive NGOs to try to launch a case using human rights law. So the case went to the Constitutional Court using international human rights law. And what I'm using that, it was the learning process with the community. So I was invited by the forest people to come to meet some of the community leaders. And Felipe, because you raised the question of who puts the name to the case. In that situation, we have 700 people that are the victim of the decision by the government. As you know, in the court, you can't put 700 victims. It's really hard, especially in that Constitutional Court case. So we had to invite the community to think really carefully on who are the victims, who will represent the case, who can put the name to the case. But what I learned from this was actually the community was a very important community building process of deciding what would be the best evidence for the community, what's the best way to frame it, And what was important was the argument, Caroline, you put about participation of the community. It was learning from, what I mean by us is the lawyers and the NGOs to go in the back foot and basically leave the community to develop what they wanted from the case. It took a few years because those things are really long to buy. And one thing is the evidence gathering. So how do you prove that this is your land when the government doesn't recognize that this is your land? So you need to have very strong evidence to put in front of the judges. And for that, the committee went back to collecting evidence from the elders in the communities, from women, the way they were relating to the land, from the children, the way they relate to the land, and build this network of knowledge based on indigenous values on the relationship with the land. Why am I going back to this? Because it took a few years, but it was really important because they built a narrative coming from the community about what for them means the property of the land. And what came very strongly, it's not about property in the sense of the Western legal system of individuals having property to the land. It's more about that relationship with the rivers, the forests, and what it means for the community. This is where human rights law could be useful because the language of human rights law allows this spiritual collective entitlement to land rights, which wasn't possible under the laws of Uganda. This has allowed us to push the argument to the lawyers and then to the judges. I'm going to be frank with you because one of the questions was the challenges. The lawyers were not ready for this kind of challenges. I don't think they anticipated what the community wanted, and they had difficulty to understand the way it will frame into the legal system of the state. But this is where human rights law was used to push back, and using those precedents from the regional courts, like the African Court of Human Rights, but also the Inter-American Court of Human Rights. It has worked in the end. There was a positive decision by the Constitutional Courts that for the first time recognized that, yes, the Batwa are indigenous peoples, yes, they are facing discrimination, and yes, they have a specific attachment to the land. Now, this is the problem of those decisions. Decision is actually okay, but the implementation is a big problem. So what I've learned as a litigator and lawyer, supportive litigator for this committee, it's we, and I say we, it's people, we are on this panel, have an obligation as well to think about supporting implementation even before the decision is made, which is very difficult because it means putting in place policies that will support the community implementation. And this is why I'm going to join Patricia. What I've learned is basically you need to work at the same time on the legal development of the country. So litigation is only used as a wedge, if you want, into the legal system, but that's only an entry point. This is to be used to actually change the legal process and allowing the community to say, oh, because we won now in the courts, it means that when there's a meeting on conservation in our land, we should be there because look, we have a decision from the Constitutional Court that says so. That Constitutional Court only serves at that as a political way for the community to say, you need to include us in that conversation. Because otherwise the government never does. I'm going to be frank with you, it's a bit of a racist thing you face with government. They don't see even the point of inviting the indigenous communities, and they feel that they're not entitled and they won't understand what is conservation. So the litigation in a way is only one tool in the broader work that Patricia is describing, which is you need to do all the rest. So I think what I will share with everybody is like what I've done in those cases, it's to learn that litigation is only one tool that you need to think about much larger strategy, but that needs to come from the community because this is what really is transformative. What's the value of litigation? Because it has this sort of magic way of forcing the community to think about evidence gathering, strategy, but also being very inclusive inside the community, putting forward the voice of the children, the women, the elders into the argumentation to the courts. So in that sense, if I go back to that case, yes, victory in courts, but also it took 10 years, I should say. It was 10 years in the building to get there. So it's a very slow process. I think this is something we need to be aware when, sometimes community wants to take litigation because they feel, that's enough. We need to take the government to court. But the warning there is the time it takes. It's extremely time consuming. We read those decisions as if, they were decided sort of fast, but in reality, this is an extremely long process. Also, it could be you could lose the empowerment of the community because it's become dragged by the lawyers, which often are in the capital city or in the big cities far from the communities. And I find that the communication between the lawyers and the community sometimes could basically be a bit loose. So I think that's also the job of maybe the NGOs to be there to make sure that it's there, that the lawyers need always to come back to the community to really work the strategy, to agree with them, because it's so important for the community to feel being empowered by the court. Otherwise, it becomes a theater, and they're not even participants. They don't, they're not even there. They're not. I've seen cases where the victims are not even in the courtroom because it's so far away from where they live. And then you do wonder what's the point of justice if if the victim cannot even be in the room. So I think there's a mission on us, when I'm talking about us, like the lawyers and the NGOs, to make sure that we are there to make sure that the communities are parts as the actors in their court case, because then it's useful for them to do the other work that we talk about with Patricia, which is the political work, forcing the institution to be there. So sorry, a bit of a long one on that one, but I was trying to connect some of the points that were made by Patricia and Caroline and you, Felipe. Happy to expand on some of those points if needed.
Okay, perfect. Yeah, I completely agree that we always have to be like visiting locally to the communities, explain them everything about the proceeding, what's the update of the case, empower them. Otherwise, definitely it would be just a theater, and we would not be different than like what the government would be doing with the communities. But it's like a greenwashing of the government, right? But on one interesting topic that you said about the implementation of the measures, once we go through litigation and we can, and if we get like a good decision, a good ruling on the case about liability against the defendant, like one thing that's really difficult, I think, for the specific of the indigenous community is quantification of damages. Like we are talking about spiritual links that were destroyed usually. Like how, on your experience, how have you been facing this part of the proceeding of quantifying the damage suffered by the indigenous community? Because how do you quantify the death of a god, for example, right? It's quite difficult to quantify.
And that's a key point, and that's something that in general legal system are useless on that front. And that's true across civil and common law. It's they're not equipped for that. They're still very colonial in the mindset of what is a remedy, but also the legal system in general don't see those spiritual values as more than spiritual and actually intangible, something that if you could be a victim of that, you need reparation for that. There needs to be a remedy. It's a slow process, and I feel like, again, human rights law has been slowly but surely starting to move into this, and the Anti-American Court of Human Rights especially has been sort of a precursor on that front, trying to make decisions that are actually meaningful in terms of reparation for the communities. So you might see sometimes you read the decision from the court and there's just a decision, but then the reparation actually is the important bit. And it's like another judgment in the judgment, if you want, sometimes, because you go into detail of what's meaningful for the community. So that's something also that I've learned across with the time, that with the lawyers, we need to spend as much time on building the evidence to win the case as building what could be a reparation that could be meaningful for the community if ever they were to win. And that could include spiritual recognition. It could include some very important tangible recognition of that spiritual value of the land. But sometimes also it's recognition of this cosmovision or worldviews themselves as part of the judgment by the government. And there I find that where human rights has been useful, because it's recognizing that spirituality is not something not important. It's as important as your freedom of religion. And if it's connecting to a land, that needs to be also acknowledged as a proper right that needs to be protected and also have remedies. So we have decisions that actually include that, this sort of spiritual level of recognition of that relationship with land. That's a bit of a segue for me to allow me to speak about a development that happened in a recent case by the Inter-American Court of Human Rights. In a case I'm currently involved in Colombia, I'm going to use this one actually. So in Colombia, the UWA community are at the moment waiting a decision by the Inter-American Court of Human Rights. In that case, they've been facing oil exploration in their land for the last 20 years. An argument they put to the court is that you cannot take the oil from the land because the oil is the blood of Mother Earth. And what I mean by this, the whole earth where they live is connected, and the oil is actually part of it. It's like taking the blood of your own mother if you do that. So they're asking the court to recognize this. We don't know if the court will actually accept the argument, but it's been put forward by the court to the courts. The decision should come in January. The hearings were a few months ago. But in this also, they ask for specific reparation. And one of them is the fact that oil should be stopped because it's basically not respecting the spiritual relation to the land. Will the court do it or not? I don't know. But close to Colombia, in Ecuador, you might have seen there was a referendum a few months ago that, thanks to the right of nature, has recognized that, yes, not taking oil from the soil is actually an important worldview by the peoples that should be respected, and that has as much importance as human rights law. So in a way, human rights law is starting to support the idea that nature, when it's part of a spiritual connection to the land, is also part of indigenous rights and should be put into the judgments and also should have remedy to that. Again, that's something I'm working quite a lot on at the moment, so happy to, in the Q&A or whenever, to speak more about this. But it's connecting to what you said, Philippe, to opening up this idea of what do we mean by reparation? What is a remedy when the land has been so devastated?
Okay, thank you very much, Professor. So we're moving to the end of our webinar. I would like to make questions of the audience to the panelists. We'll have three main ones that I would like to ask you guys. So first one, we have been discussing a lot how legislative advocacy and litigation can be used to protect indigenous rights. So, but in the opinion of the panelists, what do you guys think what is like the most has been proven to be the most effective way to protect indigenous rights? Legislative advocacy or litigation, in fact? Second question of the audience is Pogust Goodhead and ClientEarth have a lot of similarities in the work and synergies. Is there any work that you guys are working on together? And the last question for both organizations as well, what has been the main challenges and obstacles that the organizations have been suffering in the protection of indigenous rights? Attitudes, bad actors, lack of resource. So I'll leave you the question for any of you guys who want to answer.
I think I can start in relation to legislative work or litigation. I think in an ideal world, we would have a good legal framework, and that would be enough to deal with the violations of the indigenous communities. But that's not what happens. So the way I see it, it's a combination of good laws and people advocating for their rights, because more than often they won't do it. So that's my view. I don't know if anyone disagrees or has anything to add to it.
Now, just to add, it's totally holistic, because I think one of the questions was about, is it holistic? Absolutely. It goes hand in hand. And also litigation could be used to challenge the fact that the law is not really adjusted. So Colombia, again, is a good example of, you might have heard about the Atrato River that was recognized with legal personality by the push by municipal courts. So it's a way to change the law as well. So you win the case to also challenge the fact that the law needs to be changed itself. So, but the other way, you implement the law, you make the law work because you challenge the content of it and you use litigation. So I don't think we can really divide the two, which is hard for the communities because they need both to engage in policy change, but as well in litigation, which is a stretch. And one of you in the question asked about, cost and what is difficult. This is difficult for the NGOs. You have to be both a litigator and then a policy advocate, and you need to engage in community empowerment at the same time. So it's like 3 jobs at the same time, which is not easy. And, lawyers need to be sort of very technical, but at the same time, they need to be on the ground and doing that. So but I think holistic is the right word for that.
I just want to add something. I agree with both Caroline and Jeremy. It's this, like, in an ideal world, this would be like a holistic view, but I think it also needs to be adapted to the context of the country. So as I was saying, this is why, for example, we are focusing in Gabon on the legal reform processes in the forest sector, because litigation would simply be ineffective and too costly, too long, and there would be no impact. And I just want to mention that at ClientEarth, we developed a practical guide on law reforms in the forest sector, where we insist on this idea that all stakeholders should participate in any reform from the very early stages and up to the implementation. And this is what we are trying to also to have an education about in Gabon, for example.
You're on mute, Felipe.
Thank you, everyone. I think we'll have time for one last question for Jeremy. Well, it's a quite long one. Jeremy, tell me if you have time for this one. But interested to hear reflection on the update to the EU proposed environmental law to reference ecocide agreed last week. Will's lawmakers did not agree to the extend this obligation to offense committed outside EU borders on behalf of EU companies. Individual member states will be able to choose to do this as they integrate over the next couple of years. Is this a potential game changer regarding holding European companies to account for abuse of indigenous land and rights outside the bloc, especially when used alongside the Corporate Sustainability Due Diligence Directive?
Yeah, and thanks for this for the question. It's a big one, but it's so important. And I mean, by the question you already summarized it. Yeah, it's a game changer. There's no doubt. Now the question is it going to be put in practice again? And this is where our discussion on litigation might be interesting, because even if on paper it's there, we don't quite know yet the way it's going to work. But as you pointed out in the question, it opens up all sorts of important things, because we know that so many of the companies are based in EU territories, so clearly it will be relevant. We saw what happened with the French due diligence law that suddenly opened possibility for indigenous communities in Mexico to challenge decision made by a company based in France. So clearly this is going to join. There's one thing we need to bear in mind. Ecocide is so bad that the environment has been destroyed forever, so it comes at the last resort. So I think it's important also to keep in mind that we want the other process to be there, because I teach a lot on genocide, same with human rights. It's so bad that you can't recover from that. So I'm a bit worried that we put too much policy on ecocide, forgetting that we should prevent it. We need to act before it's so bad, but clearly it would be good to have ecocide in the law, especially in the EU, because it suddenly opens this game-changing integration of ecocide as a crime under international law. And I think the EU will be a good place, knowing that, yes, there are so many companies that are involved in deforestation that are located in the territory of the EU.
Okay, thank you, Professor. We are coming to the end of our webinar. I'd like to tell everyone that this is just one episode of a series of webinars that we will be hosting in Pogust Goodhead to be debating human rights and any other important issue. and I would like to invite everyone to continue this series of webinar at Pogust Goodhead. Thank you everyone for the participation and for attending the webinar. Have a good day.
Thank you.
Thanks, everyone.
Bye.